Welcome, everyone. We're going to start our semester as well as our chapters with, in our book, Criminal Courts, The Structure, Process, and Issues by Richard Hartley. Chapter 1 is called The Legal Battlefield. So we get into kind of the basic process. We're going to start looking at structures, and we're going to go from there. So first, your learning objective. These are also listed in your book as well as in your opening slides. So feel free to read through those. Law and practice. So what does that mean? Your book gives a definition of the legal system specifically as the body of rules of specific conduct prescribed by existing legitimate authority in a particular jurisdiction and at a particular point in time. So what does that mean? Obviously, law can mean different things to different people. Some might see the law as an avenue of redress for social ills in society. Others might believe that the law is used only as a mean to maintain the status quo and the powers of those in the ruling class. The law is both and can be viewed in many ways by many different people. Great examples of the legal system or laws at work would be all the movements going on right now, whether it be Black Lives Matter, whether it be COVID. You can talk about so much in different structures here in both what's legal. Obviously, peaceful protests are legal and within our rights as citizens, but there are things that are not legal. Looting stores are not legal. Murdering individuals obviously is not legal. So we have to find a balance and make it work for our system. And obviously you guys are the face of the new generation, and you're going to have to figure this out on your own to figure what works. The criminal justice system is basically the legal system with laws and punishments, and the actors are responsible for apprehending offenders, charging them, asserting guilt, and meeting punishments. Now, a lot of people, when they think of the legal system, obviously they think of law enforcement. Maybe attorneys come to mind, judges, but every individual is part of the legal system. So whether it be a victim of a crime, whether you're the perpetrator of a crime, whether you're a family member of a victim or a perpetrator, you could have a family member that's wrongfully convicted or accused, obviously even jurors. So everybody is going to play a part in the legal system. Obviously, from the attorney's side, you're going to have prosecution, defense, and a judge. And they're going to present a case, whether it be innocent or guilt for the individual that is charged with a particular crime. And we'll go through kind of how that works in terms of the criminal system and how that's different from the civil system in our society. Court functioning. We have several different functions of law. There's two broad philosophies that we look at. Obviously, one is a legal institution, and it focuses on the particular rules and procedures. The other is a community where independent actors rely on one another to perform their roles, and their relationships that influence the process and practices. Notwithstanding the manner in which one views the role and functions of court and society, there are several different kinds of laws or rules that attempt to govern our behavior. These are laws against many violations we may or may not know exist, but are in place just to protect us from things that may harm or injure us. Law is dynamic and has many definitions. In your book, you're going to look at different social functions of law, so whether it be social control, dispute resolution, and social change. So we'll get to those in a second. In different states, it's not mandatory to wear a helmet when riding motorcycles or bicycles. In California, that is a law, and you are required to wear one to protect you from any harm that may injure you. Some of you are going to agree with that. Some of you are obviously not going to agree with that, and that's how we can kind of change our social standards and depict the law accordingly. Again, we already went through what is law, specific rule of a body of rules for specific conduct. Our sources of law. So when we're looking at law, we're looking at statutes, then constitution, court decisions, which is case law, and then administrative rules and regulations. So think of Social Security or workers' compensation, or schools have obviously administrative rules and regulations. The functions of law, as I mentioned just a minute or so ago, we're going to look at social control, dispute resolution, and then social change. So what is social control? Well, it's society's efforts to regulate the behavior of its members. Informal social controls are a huge part of the socialization process. And in early childhood education, we teach the norms of behavior that our parents and social world expect us to have. So specifics, you don't hit other individuals while you're in school. Obviously, you're polite or respectful. Or you always go back to the golden rule, how you want to be treated, you treat others. Now, dispute resolution is where there may be an issue with social control or social norms. People are in dispute all the time. Some resort to the legal system. Obviously, let's say two kids get in a fight on the playground. Who is the legal system in that particular instance? Well, it would be obviously the teacher, the principal, the yard duty, but some individual is going to help those children resolve their issues. They may rely on the legal system to resolve the issues that once were settled privately. So name calling, blaming, claiming something. And a major change in our social dynamics is largely responsible for any of this shift. So, there are lots and lots of frivolous lawsuits out there. And sometimes those can be solved very easily by one individual speaking with the other. And unfortunately, sometimes it goes into the court system where it doesn't necessarily need to be. Easy ways of dispute resolution include arbitration if necessary, or informal methods. You can look for civil actions against individuals to either incur an injunction, so stopping an action from happening, or potentially getting some sort of monetary compensation for whatever happened. Social change is what we're trying to modify by our legal rules and standards. I had to cut for just a moment, so we're going to jump back into social change. And I know we spoke about most of it, but obviously the legal system and laws are what help enact social change in our world. And obviously, as what we are going through in 2020, there is a lot of call for social change, and we'll see if the legal system reflects exactly how society is implementing that social change. So there's several different types of law. Typologies of law are both important and necessary, and laws vary according to who prosecutes, the nature and the types of the penalties, and its particular historical origins. The two types of law that your book is going to really focus in on are substantive law and procedural law. So there's also common law, which is what our legal system is built on, our criminal law as well as civil law, and administrative law, which is a little subset of civil law, essentially, but it's more governmental in function. So substantive law is a combination of local, state, and federal laws created by legislature. A law exists that defines when someone is under the influence of alcohol when operating a motor vehicle. So it's very specific in what it says. Procedural law is how we put the law into action. So procedural law includes how a person or persons should be sentenced when convicted of one or more type crimes. Common law, again, is whatever is prevalent, traditional, or customary in our given jurisdiction. Judges decide cases by common law on the basis of what is customarily or traditionally found. Common law is judicially created law compared with law made by legislator, not magistrates. They are magistrates. And common law gives us our basis of how we make decisions in the legal system, or another word for it is stare decisis. And your book talks about how American society has become formalized with law, that we started from English common law, but then it changes over time to reflect our social changes. Your book used the example of prostitution. So many urban areas do not condone prostitution, although some prostitution exists and is accepted informally, especially in states like Nevada. Civil law originated from Roman law. We contrast it with common law. It stresses codification. So civil law in America is used to resolve disputes between private parties. So in civil law, you're going to have say Bob versus Sam. There's going to be no prosecutor or no state of California versus an individual. When we get into criminal law, that's what we're talking about. So this is where society brings an action against a specific individual or individuals. Punishments under criminal law are more severe and usually include incarceration or some sort of probation, whereas civil law is only going to include some monetary compensation. And then administrative law is the body of law, rules, orders, and regulations created by administrative agencies such as Social Security, the Department of Motor Vehicles, the Department of Education. There are more than 50 federal regulators that promulgate and enforce a diverse array of regulations. And then we're going to look at the sociological aspects and perspectives of law. So law is part of, obviously, the social order. It coexists, interacts, and competes for resources. It is concerned with how law operates in our society and in reality, and it's also concerned with observing how groups of members affect what we expect from law. So your book looks at the sociological jurisprudence, which holds that there is a part of law should be devoted to making or shaping public policy and social rules. This interaction has its roots in early American writing, and it's believed that there are 3 active, dynamic, and useful changes for social order. As we grow and change and other activities are accepted in society, we want to make sure that we're able to change and ebb and flow. Legal realism, on the other hand, is the perspective that is described in the work of Carl Linwin. He argued that law was dynamic and often inconsistent, which I'm sure many of you probably feel like looking at the legal system. Realists also believe that law should be the means to an end of social change rather than the end of itself. They were distrustful of the legal rules and the perspectives of the rule information. He also believed that understanding the law was inadequate. He believed that law and society were constantly evolving and that individuals that practice law should continue to work and evolve it for better. And then we're looking at critical legal studies, which is one of the most dynamic and controversial perspectives of law. The movement involves a thorough examination of the entire legal system, and the study takes issues with formal rational law. Lastly, the feminist legal theory protects male interests. The rationale for the view is that women reason differently than men, and therefore, as lawyers and judges, women will use a different type of logic when applying law. We want to make sure that because of that reason that we want to have equal parts of female and male in our legal system to make determinations. Lastly, legal system versus legal culture. We're going to spend a lot of time on that in the next few chapters, but we want to look at the actual structure of implementation and then the cultural of how society is changing.